Curious about parental rights, independence of minors, and protections for vulnerable adults? This video is part 2 of 3, where we are continuing our review of Chapter 12 of the 2025 Fundamentals of Louisiana Notarial Law and Practice Book. Let's cover these additional concepts you should know as detailed in the chapter titled Of Persons, the Family, and Marriage. Let's start with parental authority. In Louisiana, parental authority refers to the set of rights and responsibilities parents have toward their minor children. It includes both the privilege and obligation to care for, rear, educate, supervise, and make decisions regarding the upbringing and welfare of their children. Under Civil Code Article 221, parental authority during marriage is jointly held by both the mother and father. This joint authority remains intact throughout the marriage, allowing both parents to share equal responsibility in all matters concerning their child's upbringing, from education to healthcare decisions. Parents may choose to delegate some portion of their parental authority temporarily. Civil Code Article 233 explicitly allows parents to entrust teachers, caregivers, or others responsible for the child's education with certain elements of their authority. However, delegation does not relieve the parents of their ultimate responsibility. It simply empowers others temporarily for specific purposes. When a marriage ends or when parents separate, as per Civil Code Article 234, parental authority adjusts accordingly. If a court grants custody to one parent, parental authority becomes subject to that custody order, meaning the custodial parent exercises primary authority, although the non-custodial parent typically retains certain rights and obligations, as determined by the court. Parental authority encompasses several crucial rights and responsibilities, including representation, administration of property, and alienation or lease of child's property. Parents represent their children in legal matters and can act on their behalf. This authority extends to designating tutors or custodians to act temporarily if necessary. Parents have the right and obligation to administer the child's property prudently and solely for the child's benefit. This responsibility requires careful management and prohibits misuse of the child's assets. Parents may not alienate, encumber, or lease their child's property without specific legal approval. Any such actions generally require authorization from the court to ensure the child's interests are protected. Parental authority is a significant legal relationship shaped by marital status, custody arrangements, and specific court orders. It underscores the responsibility parents have to act primarily and consistently in their child's best interests. When parental authority ends, such as upon the death of parents, separation, or another qualifying event, Louisiana law provides for tutorship, a legal mechanism designed to protect and manage the affairs of minors. Under Louisiana Civil Code Articles 246 through 250, tutorship ensures minors have someone legally responsible for their care, custody, education, and the prudent administration of their property until they reach the age of majority or are emancipated. There are 4 principal types of tutorship defined by the Civil Code. First is tutorship by nature. This occurs automatically upon the death of one parent if the other parent is alive. The surviving parent assumes the natural right and responsibility to care for the minor child without any need for court appointment or formal proceedings. Next is tutorship by will. Parents may designate a tutor in their will to assume responsibility for their minor children upon the death of both parents. This method allows parents to proactively choose a trusted individual or individuals, ensuring their children are cared for according to their wishes. Third is tutorship by effect of law. In cases where no tutor has been appointed by will and no parent survives, tutorship automatically falls to certain relatives, typically grandparents or nearest next of kin, as designated by law. And finally is tutorship by appointment of the judge. When none of the above categories apply or are available, a judge will appoint a suitable person as tutor, considering the best interest of the minor. This appointment prioritizes stability, competence, and the well-being of the child. Additionally, special provisions address situations involving children born outside of marriage. Under Civil Code Article 256, if a child is not filiated to both parents through marriage or acknowledgement, the mother is the exclusive natural tutor. If the father acknowledges the child, He may also become eligible to be appointed as tutor if deemed in the child's best interest by the court. Upon assuming tutorship, the appointed tutor must responsibly manage the minor's assets and property. The tutor is accountable for prudent financial management and cannot alienate, lease, or encumber the minor's immovable property without specific court authorization. The tutor's duties and performance are subject to oversight by the court, ensuring transparency and accountability. Tutorship thus provides a comprehensive legal framework intended to safeguard the well-being and property interests of minors until they can legally care for themselves. In Louisiana civil law, emancipation is a legal process that grants a minor certain rights typically reserved for adults, effectively allowing the minor to act independently before reaching the age of majority. The law recognizes three primary forms of emancipation, each offering varying degrees of independence. First is judicial emancipation, which grants a minor the full legal capacity to perform nearly all acts usually reserved for adults. Under Civil Code Article 366, a court can grant emancipation when there's good cause, such as when a minor demonstrates maturity and the ability to manage their affairs responsibly. This form of emancipation is granted through a formal court proceeding. The minor gains extensive autonomy, including managing property, entering contracts, and conducting business independently. Judicial emancipation becomes effective immediately upon the signing of the judgment by the judge. Second is emancipation by marriage, which automatically emancipates a minor, providing them with the legal capacity of an adult. Under Civil Code Article 367, emancipation by marriage is immediate upon the celebration of the marriage ceremony. It remains effective even if the marriage subsequently ends through divorce or death of a spouse. Once emancipated by marriage, the minor retains this status permanently and continues to hold the rights and responsibilities of an adult, notwithstanding marital status. And third is limited emancipation by authentic act. This method is specifically designed for minors age 16 or 17. It grants minors a defined set of adult capacities through an authentic act executed by the minor's parents or tutor before a notary and two witnesses. This method allows parents or guardians to tailor the emancipation, granting certain specified rights, such as signing contracts, managing specific assets, or conducting certain business activities, while withholding others. Importantly, this form of emancipation provides a balance, empowering the minor with independence in selected areas while preserving parental oversight in others. Limited emancipation by authentic act can later be modified or terminated by another authentic act, or through a court judgment, ensuring ongoing flexibility based on the minor's needs and circumstances. Civil Code Article 371 provides that limited emancipation can be adjusted or ended entirely either by another authentic act or through a judicial ruling if circumstances change. For instance, parents may initially grant limited emancipation for educational purposes or business reasons, and later decide to expand or withdraw these freedoms as necessary. Louisiana law carefully balances a minor's right to independence with protective measures to ensure the minor's best interests are served. Courts scrutinize the minor's maturity, the nature and purpose of the emancipation, and the minor's overall capability to responsibly manage their affairs before approving emancipation requests. Thus, emancipation under Louisiana law offers minors a legal path to independence and responsibility, accommodating diverse individual circumstances while providing essential safeguards for their welfare. Under Louisiana civil law, interdiction is a protective legal measure established for individuals who, due to physical or mental limitations, cannot manage their personal care or financial affairs. It involves a court determining that a person, referred to as an interdict, needs someone else to oversee critical decisions concerning their health, finances, and general welfare. A full interdiction is the most comprehensive form, completely removing a person's legal capacity to act independently. According to Civil Code Article 389, a court may order full interdiction when an individual of majority age or an emancipated minor is consistently incapable of making reasoned decisions about their care or property due to mental or physical infirmity. Under full interdiction, a curator is appointed by the court to make nearly all decisions for the interdict. This includes managing the interdict's financial affairs, medical treatment decisions, and general personal care. Essentially, the curator steps entirely into the interdict's shoes, legally safeguarding their interests. Limited interdiction, as described in Article 390 of the Civil Code, is a less restrictive form of intervention. It's designed for individuals who can make some decisions independently, but may lack the capacity in specific areas, like complex financial transactions or healthcare choices. The court identifies precisely which rights are removed and appoints a curator with limited authority, tailored specifically to those areas. For instance, a person who can handle basic personal care but struggles significantly with financial matters may receive limited interdiction, granting the curator authority solely over financial decisions. The curator plays a central role in interdiction. Under Article 392, the curator is appointed by the court to represent and manage the affairs of the interdict within the specified limits set by the interdiction judgment. The curator must always act in the interdict's best interests and is required to manage their affairs prudently, ethically, and with care. Curatorship may extend to accepting donations, managing property, consenting to medical treatments, and otherwise protecting the interdict from harm or exploitation. Importantly, a curator cannot consent to certain highly personal decisions without court approval. For example, consenting to sterilization or abortion procedures on behalf of the interdict. Curators have specific duties, which include maintaining clear records of financial transactions involving the interdict's assets. They must seek court permission for significant financial or personal decisions outside the scope of their initial authorization. Additionally, curators are required to file periodic reports to the court detailing the interdict's personal and financial status. The law imposes careful judicial oversight to ensure that curators act appropriately, protecting the interdict's interests and autonomy to the greatest extent possible. Interdiction is not necessarily permanent. If the interdict's condition improves, they or someone acting on their behalf can petition the court to modify or end the interdiction. This flexibility ensures the interdict's rights and independence are preserved whenever possible. Thus, interdiction under Louisiana law is fundamentally about protection, preserving the dignity, autonomy, and welfare of those who cannot fully advocate for themselves. This concludes Part 2 of our review on this chapter and should provide you with a solid understanding of Louisiana's civil law regarding parental authority, tutorship, emancipation, and interdiction. But don't stop here. Be sure to like, subscribe, and hit the notification bell to stay updated when I drop the video for Part 3 and for more chapters from the 2025 Fundamentals of Louisiana Notarial Law and Practice. Have questions or topics you'd like to see covered next? Drop a comment below. I love hearing from you. Thanks for watching, and I'll see you in the next chapter.